Hey folks, this is Rob Wells here with you from the Law Office of Robert M. Wells. Our office helps out landlords and property managers deal with their landlord-tenant situations and problems. In this video, I'm going to talk about breaches to the lease agreement and what type of breaches can you bring to the court other than non-payment of rent and how you should bring about those breaches. Before we get into that topic though, landlords, property managers, if you're facing a situation where your tenant has violated the rental agreement and you need help determining your rights and figuring out if terminating the tenancy is an option, please feel free to reach out to us below. Now let's begin. Now, I just got back from eviction court this morning, and there was a particular case today that kind of caught my eye, and it kind of got me thinking while I was waiting in line for the court to hear my case. And this particular case involved a notice to perform and a notice to quit under the Tenants Protection Act, where I guess the tenant had brought in an unauthorized resident, and also too they had an unauthorized animal, so to speak. And kind of sitting there, it was kind of like a 30-minute type of trial. I don't know what happened with it because they continued it, and then I got heard, and then I just left. But from the sounds of what the case that I heard was, the tenants were making defenses that the landlord breached fair housing law with failing to allow they're calling the dog, in this case, a service animal, and it looks like the landlord might have been aware of that, so they were playing that affirmative defense. And then also too, they were arguing that the court or the judge shouldn't, evict the tenants for, the failure of having an unauthorized resident. And in this case, they were talking about, there was a requirement that the tenant provide a application, and it was an incomplete application, and they were going back and forth about whether or not there was a breach or not. So here's the deal. This is how I look at it, and this is how the law looks at it. So in order to evict a tenant or terminate a tenancy for cause for breaching a term of the lease agreement, the breach has to be material. It has to be substantial, basically. And the way I look at substantial breaches are in terms of the lease agreement is that term in the lease agreement is there for a specific reason. For example, tenant is not to cause a nuisance and disturbance to residents and guests in the public at large, basically. Those lease provisions are going to be enforced by a court. And if you can show a court that, hey, you have this provision in your lease, your tenant is causing some type of nuisance, that conduct in the lease that's prohibited against the lease is something that is reasonable. It's material because we don't want tenants or persons causing nuisances to other residents. A judge is going to be able to follow along that train of thought, that provision is in there to prevent, the landlord from getting complaints and getting cited from the city or other private entities that may come after the owner for maintaining a nuisance. That's easy to follow along. Where I kind of get into trouble, I get a lot of angry landlords sometimes, or they may have a provision in the lease, like let's bring up this occupant provision that I was just talking about that we were in court on. Basically, I've seen some leases say, hey, you only can have unauthorized, authorized residents on the lease. That's a given. We don't want, tenants to sublet or assign their leases to entirely different people that the landlord has no knowledge about, okay? Courts will enforce those provisions, where I think in this case, they might have had some issues with it. There was a provision in the lease that says, hey, you got to fill out a application for rent, basically to see if you qualify to rent the apartment. And I got issues with that a little bit in the sense of, if let's say you have one tenant A, right? You rent them out your home for a year lease. Basically, you qualify that tenant or that applicant and you sign them up, and they're the only person responsible for the lease. Well, in this case, it looked like the tenant was asking to be added as an authorized resident, but the landlord was using terms in the lease saying, hey, you have to fill out all this financial information and so forth. And I don't know how a judge is going to take that, because if I'm tenant's attorney, I'm going to argue, listen, you qualified the tenant on his financials alone. And if that case came to my office, basically, I would think, you know what we can do is this, okay? I need to have the resident, the proposed resident's information, such as their name, address, maybe give me a driver's license or so forth, because that type of provision could be enforced in court, because under California law, authorized residents are entitled to notice of any default, or terminating of the tenancy, such as, let's say your tenant doesn't pay rent. Well, if there are 3 other occupants, I have to notice them. So I can justify that type of provision in the lease. And if the tenant refused at that point, I think a court or judge would have no issue with, terminating the tenancy if the tenant failed to comply. But in the particular case I was sitting in, I don't know how that's going to play out. Because if the landlord was demanding financial information, I'm going to argue, well, you already have the information of the tenant 1. Why couldn't you just say, hey, we're just going to add you as an authorized resident. You're bound by all the terms and conditions of the lease, and the landlord could have done it that way. They're kind of making some reasonable accommodation arguments under fair housing law, under federal and state law as well. What that is in a nutshell, folks, is it's a request by the tenant due to some type of disability or handicap or something. It could be anything, medically related, basically, making an exception to the landlord's lease terms or policies and procedures. And you got to be careful with that in a lot of cases, because it's particularly in California, family status and composition is protected under state law. And if you make the wrong move, if you don't do what you need to do in fair housing cases, such as at least have a meaningful discussion, which is one of the requirements under both state and federal law, you can be in hot water even if you win the eviction, because you may have a fair housing type of complaint either under state law or federal law, depending on the circumstances. So this area is kind of tricky. I've seen a lot of landlords that kind of just go, well, the lease says this, that's that, Wells do the eviction, and we got to kind of have to temper our landlords down a little bit and go, no, it's a little bit more complicated than that. There are a whole little other issues as well, too. Sorry, this video went a little bit longer than my usual videos, but it was kind of like a rant, kind of some war stories happening in court. And, we'll come up with some other videos about certain lease violations. But, in general, for eviction cases, the breach has to be material. It has to be something, like there's some type of connection why you have a policy or procedure. Some terms are obvious, like, hey, you can't cause a nuisance, you can't be disturbing people. But in other cases too, a judge may say, hey, this isn't a type of breach where it's warranting terminating someone's tenancy. So I don't know what happened in that case. Hopefully they work it out. But landlords, property managers, if you're facing this type of issue, it's best that you talk with legal counsel. And if you're in our area, we can talk to you as well too. So until then, we'll see you next time. Thanks.